This is the Investor Connect podcast program. This is Hall T. Martin. I'm the host of the show, in which we interview angel investors, venture capital, private equity, family offices, and many other investor groups for startups and growth companies. I hope you enjoyed this episode. Thank you for joining us. Hello, this is Hall Martin with Investor Connect. Today we're here with Chris Ezold, partner at Wisler Pearlstine. Wisler Pearlstine is a Pennsylvania-based law firm specializing in business employment and corporate law. They help startups and investors navigate legal challenges, including non-compete and non-disclosure agreements. And today we're going to talk also about lawsuits. Christopher, thank you for joining us.
Thank you for having me.
So where are you calling from today?
So I'm from my home office, as you can see, right outside of Philadelphia, but our main office is in Bluebell, again outside of Philadelphia, and we have several other satellite offices. My practice is national for a number of issues, and I'm licensed in Delaware and Pennsylvania and New Jersey. Although my Delaware license is currently inactive. I closed my office down there some time ago.
Great. Well, one of the key issues I hear from investors is the issue of lawsuits. Should we pursue them? Should we not? And how do we manage that process? And so I wanted to dive into that today and talk about, first of all, what are the most common types of lawsuits that startups and growing businesses face, and what typically triggers them?
It's hard to say what the most common are because a lot of these things end up in arbitration, which is confidential. But what I see a lot are, in no particular order, violations of non-competes, non-solicits, etc., where another company says, hey, you took one of my people and now he's using our information, or she is soliciting all of our clients. That's a major one. Another one is investors saying, wait a minute, you didn't reveal the necessary risk factors to me. And now I invested and I never would have if you'd followed the rules. Another is general breach of contract. I mean, these are smaller things like failure to pay rent or failure of a vendor to produce something to the other side. And then you get intellectual property issues. Most of these startups are going to have some kind of intellectual property, and there are frequently going to be disputes. If you've licensed it out of university, there can be a dispute there. I've seen a lot of that. If another organization has a piece of intellectual property that's close to yours, or if they claim you took it from them, then that can end up with a fair amount of litigation as well.
So there's different ways to pursue this. How do companies decide whether to go after litigation or arbitration or mediation? And how do they decide what factors to weigh when choosing those options?
Arbitration is almost always gone into because it's required by a contract. They've entered into an agreement that says if there's a dispute, you will arbitrate it. And the value of arbitration is that it's confidential. It isn't something publicly filed. So people can't search your company and find a lawsuit in a federal or state court. The downside is the word arbitration is Latin for you will buy the arbitrator a boat. Because now you're paying the judge as well as your attorney, as well as dealing with the overhead. And while arbitration used to be faster and less complicated, it is no longer faster and less complicated. It frequently has as much discovery, takes as long. Arbitrators are frequently former judges, and this is how they've always operated. And former litigators, this is how they've always operated. And they also know the truth isn't something you get at unless you do a thorough review of all the evidence. So the value of it tends to be confidentiality and not cost. And that's one of the major reasons to do it. And that's one of the major reasons to put it into an agreement. Mediation, you pay a mediator to sit down and try to bring the two of you together, which usually means the mediator is going to beat both of you about the head and neck and try to get you both to a place where nobody is happy with the result. That means that everybody will have settled and the issue goes away. Sometimes a mediator will look at it and will say, well, this is a clear-cut issue. There's no way this isn't going to win for one side or the other, and that changes things. Mediation is sometimes in agreements. I find that if it's in an agreement, but you don't want to mediate, then it's not going to work. It's worthless. The only reason to go to mediation is because both sides think it's worth it. Sometimes the attorneys say, you know what? My client's crazy. They're not going to listen to me, but they may listen to an experienced mediator. And so the attorneys bring a mediator in to beat their own client around the head and neck to get, to listen to some sense. So generally the only reason to do it is because you think you're close and you think there's some really good issues that a mediator can, move the other side on, and you think the other side is rational. If you think the other side's completely irrational, a mediator's a waste of time and money.
Hmm, that's good advice. So, what preventive measures, like well-drafted contracts and internal policies, can help businesses reduce the risk of being sued? How does that play out?
So due diligence plays a large part. You do due diligence on your employees that you're bringing in. Make sure they don't have non-competes and non-solicits. Make sure your agreement says if you have one, you will show it to us. And if you have one, you will not violate it. And make sure that if someone comes in and they tell you they have a non-compete, you do the right thing. I've seen a lot of companies say, all right, you're not allowed to work in Georgia and Texas and Louisiana. So we'll say you're working in California and your job description will be sales, California, but you're really going to be working in Texas, or you're just going to be giving all the leads to our Texas guy, and then you'll be making some calls, etc. So it's a sham, and that always gets discovered. Another thing is transparency. If an employee is coming to the organization and they're hiding their new employer, you, from their old employer is going to get suspicious right away. Transparency often helps stop the assumptions that someone's engaging in bad behavior. Due diligence applies to contracts. Don't hire a vendor that's got a bad track record. Don't hire a vendor that can't do the job because they don't have the people, they don't have the resources, they don't have the experience. Just because they're cheapest doesn't mean they're best for you. And you have to be very careful about seeing a low dollar number and deciding, oh, that's who I want to go with. I've seen businesses who were stopped in their tracks because they've got an agreement that's exclusive and they're not allowed to go elsewhere to manufacture, but their manufacturer can't do the job. And so they have a choice: go elsewhere, maybe get sued, file a lawsuit themselves, or sit there for 6 months doing nothing. None of them are good choices. And if you have that kind of vendor, the chances of them having the money to pay damages is really low. I've seen a lot of contracts written by people that don't write contracts. They'll pull them online, they'll fill out forms, they think it'll work, and it absolutely doesn't. It is worth your time to get a contract reviewed by an attorney. And frankly, every business should have an attorney that knows them and their business, that knows their vertical, that knows their own particular product or service, that knows the people that they have. Without someone who really knows you and is a team member, you've got someone who's shooting in the dark half the time, and that's also not a good idea.
So, how do non-compete and non-disclosure agreements end up in court? What are some best practices to avoid legal battles over those agreements?
They end up in court because someone says, hey, wait a minute, you have my employee. And they approach you and they say, here's a non-compete. My employee is a non-compete, or they have a non-solicit and they've gone after my clients. And you look at it and you say, well, tough. At that point, the former employer has a potential claim of what's called tortious interference with contract. That is, I have a contract with an employee and you're making him break it. So I can sue you for those damages. And the former employer will sue you, will sue the employee, will file a complaint, generally in state court, sometimes in federal court, and will at the same time file a motion asking the court to temporarily order you to not hire or allow that person to work, and ordering that person to not work for you. And when I say temporary, it's because that order only lasts until trial, which is 1 to 2 years away. And at trial, if they win, it becomes permanent. And if they lose, it goes away. Well, if you lose, if at that point you get an order preventing your former employee from working, that's usually the end of the deal. No current employer is going to want to wait a year or two to see if this person can come back, right? So very frequently that order, that hearing on that order is a mini trial. It occurs somewhere between 2 days and 3 months from the filing of the complaint. And I say that because it depends on how urgent it is and whether you convince the court to, schedule it early. That hearing usually ends the process. Because if you win, now, then the other side isn't going to want to go all the way to trial because the judge that will hear it at trial has just heard it and ruled against you or ruled in your favor, depending. So It helps avoid all the expenses of going to trial, but at the same time, it is not inexpensive in and of itself. It's $25,000 to $75,000 depending on how complicated the issues are. The way to avoid that is to make sure you look at it, get a good legal opinion before you hire the person. Make sure all your employees give you whatever non-competes or non-solicits they have, and get an opinion of how it would be defensible. Your attorney may say this is completely defensible and it'll cost you $50,000, and you'll say, well, it's not worth bringing that person on. Even if you're in the right, it may not make business sense. And being able to evaluate that requires generally the opinion of counsel.
Good point. So, how does the possibility of lawsuits impact a startup's ability to raise funding? And what do investors look for regarding companies' litigation history or exposure?
So the litigation history plays a part because an investor wants to know if A, you're, I don't want to say stupid, but if you're inexperienced enough to keep walking into litigation, if you keep screwing up and annoying other people such that they sue you. No investor wants to invest in that because you're going to keep doing it. That's their thought. If they see that, well, you haven't been sued, you aren't suing anybody, but your contracts are a mess. You don't know if your employees have non-competes. You don't have non-competes with your employees, so they can go take your intellectual property, they can take your clients and customers, et cetera, and go elsewhere. They're also going to be less likely to invest because they want you to be protected. They're putting their money in, they want it to be protected, and it's only protected as far as you are protected. That's why if you have intellectual property, every investor asks, do you have a patent? Do you have a copyright? Do you have a trademark? How do you know? Do you have prior art? Do you have a letter allowing you to go out and do what you need to do? These things make people want to invest when you have those protections. And the same is true for your contracts and your employment and everything else.
Well, great. So, in highly regulated industries like healthcare and biotech, what are some unique compliance issues that lead to lawsuits, and how can businesses prepare for them?
Right. So in those industries, you don't have to worry just about opponents in the marketplace. You don't have to worry about former employers coming after you or your employee. You have to worry about the government. You have to worry about Stark and anti-kickback in healthcare. And you have to worry about anti-kickback in any other government contracting. At the same time, there's regulatory issues. You could have this amazing piece of technology that will take patient information, aggregate it, come out with some amazing conclusions using AI that are very valuable. But if you're violating HIPAA to get the patient information, all you've done is create a liability sink and no one will buy into you, nor will they buy your business. So you need to make sure that you have the right people on the regulatory side. And that's not just lawyers. A good regulatory employee, someone who's been inside the government, is usually best to be able to tell you, here are the things you need to worry about. Here are the loopholes. Here are the hurdles. Here's how you prepare for them. And mapping out how to deal with these legal regulations is critical because you generally can't comply with them on a week or two's notice. You need to know when you're going to have to comply with them and what you have to do and prepare for it and get it done. Each of them is a project in its own right. So you'd think, all right, well, that's just the government trying to stop us from making money and trying to do business, and it's crazy. And it does make it more difficult to do business. But if you look at it the other way around, wait a minute. If we know how to do business in this regulatory section, and we're good at it, and we don't trip up, and we've got the right people, then we're that much more valuable because our competitors will screw up. They won't hire the right people, they won't pay attention to the regs, they'll ignore something, they'll just do the wrong thing, and people will be less likely to invest in them and less likely to buy them. But if you're clean and you're competent, you are much more attractive to a buyer. Investors, you're more attracted to investors, but many of them don't know what to look for. And when they do, they're willing to overlook bumps and scratches and dents in the business because they're excited about the outcome and they figure things can get fixed. But a buyer who's coming in to buy your business, buy your product, buy your assets, they are not interested in buying your liabilities. And the more liabilities you have, the harder it is to sell and the lower your value. So this really has long-term impact on your valuation, on your multiple, and it's absolutely worth making sure you get it right to start.
Well, great. With data breaches and privacy regulations on the rise, what are the most common legal pitfalls related to cybersecurity, and how can companies mitigate those risks?
Sure. So I believe in a decade or two, this is going to be called, or what is behind this will be called the age of privacy. We had the age of flight, we had the jet age, we had the industrial revolution, et cetera. We had the age of privacy, and it probably lasted 3 years. It's been over for a long time. Data is far more vulnerable than we realize, and the people stealing data are way, way ahead of the safeguards that are out there. That being said, some of the big pitfalls are not making sure that you do what you need to do to protect your data. Most data is compromised because of employees. Somebody gets an email and clicks on a link they shouldn't. Somebody puts something on a thumb drive and leaves it somewhere. Somebody emails it to their Yahoo account because they want to work at home. And all of a sudden, the data is out in the wild. Making sure employees know what their risks are when it comes to somebody else trying to manipulate them into sending data out is one of the best things you can do. It's not very expensive. There are plenty of vendors who will run monthly tests where they will send emails into your employees saying, "Hi, I'm the CEO. I need help. I'm out at a client site. I need some Apple gift cards right away." And which is a common scheme, believe it or not. And then they'll do it, or they'll say, "Here, we're your bank. Click on this. We need to make sure you have the right escrow funds, blah blah." And they'll click on links and give information out. And sending these tests out actually has the employees seeing these things, reacting to these things, starting to realize when they're wrong, because when they get caught, it's embarrassing, right? And it's not like you need to let the whole company know that this guy screwed up or that she went and clicked on something she shouldn't. But you can get a report at the end of the month saying, "Here's what you did wrong, and here's what you should do." And they can also send out little vignettes, little videos with little tests after them, maybe 15 minutes, if that go over a very specific area of phishing, data privacy, security issues. Educating your people is not expensive, but it's absolutely critical, especially if you are an intellectual property focused organization, and especially if your intellectual property is a trade secret. And the reason is a patent is enforceable if someone steals your IP. A copyright is enforceable if someone takes your stuff and prints it. But a trade secret is only enforceable to the extent you tried to keep it secret. If you don't keep it secret, the court says tough, you lose. And all of a sudden, one little error where it got out and did no harm meant that it got out. And that means your trade secret is gone. And if a competitor knows about that, they can say, "Hey, did no harm, but it's out, so now we can use it." So keeping your employees aware of what needs to be done, making sure your trade secrets are carefully kept secret, that only the right people have access to the right parts of your trade secret, and everything else is under physical and digital lock and key, is critical. And the education piece is as well.
Great. So, what factors should a business consider when deciding whether to settle a lawsuit or proceed to trial? And how do cost, reputation, and precedent play a role?
It's always a business decision, especially when you're a startup or you're an emerging growth company, you're looking to be sold. Because if you sue or settle on principle, you're going to end up spending an enormous amount of money or getting less money, and unfortunately, not getting what you need. Principle's nice, but it doesn't help when you're an emerging growth company. The only person that really makes out in a lawsuit based on principle is the attorney. I get to bill, I get to do what I want to do. I end up spending a lot of my clients' money, and I don't think it's worthwhile. I don't like it at all. So I tend to push back on that. Having said that, a settlement is usually driven by how much are my legal fees and how much am I likely to get in whatever area I'm in, whether it's mediation, arbitration, litigation, etc. It's a risk reward analysis, and it depends on the risk tolerance of the organization as well as the need. For instance, if you need a 100% win on a patent claim in order to be able to sell your company, you're never going to settle. You're always going to go for that 100%. Using these metrics is usually good to think about early on to decide if I'm going to get into a conflict, what will I do? That'll give you a much better idea of where you need to tighten security, where you need to be more careful. Because if there is litigation you must avoid, then you want to figure that out way before you actually get into it. Legal fees are a big part. Many startups cannot afford litigation. Litigation is not cheap, especially if it's IP litigation, et cetera. If you have someone who is violating their non-compete and you go through a lawsuit and you go through that initial hearing, you could spend $100,000. Maybe you only spend 35, but 35 is a lot of money to many organizations. 100 certainly is. And if you can't afford the lawsuit, well, that settlement becomes pretty obvious right up front.
Great. So, which upcoming legal challenges or trends do you see shaping the lawsuit landscape for startups and investors in the coming years?
Obviously, we're having a lot of changes with regards to non-compete law. There was an attempt to restrict that nationally. It didn't work, but many states are enacting their own non-compete restrictions. And some of them it's entirely illegal. Others are very narrow. You can't restrict a doctor, but maybe you can for a year, things like that. So you have to know that landscape. And that's going to develop for a while. Privacy and cybersecurity is absolutely a developing area. We have a patchwork quilt of laws nationally where Massachusetts and California and other states have very restrictive laws and others have little to none. But almost no business, especially an emerging growth business, works in a very local area anymore. These emerging growth businesses have employees in 5 states, and they've got customers in 30 states, and they want to sell to somebody else in a 40th state. And all of that data that they're generating, well, it sits in a 50th state. So what law applies? And what happens if data goes over a state line? And what happens if two laws conflict? Whose law do you comply with? A lot of these questions are not answered, and I think it is likely at some point we'll see a national privacy and cybersecurity structure put in place, but that's a fair ways off. In the meantime, making sure that we can navigate this minefield is going to be very important for a lot of my clients. Another big area that I think is going to develop into more of a minefield is whether or not a company is going to be able to get the investment it needs from the people that need to invest. We have a very robust structure right now where the SEC requires organizations to jump through certain hoops to get investment from the right investors. But we're all seeing the emerging growth of crowdsourcing and people investing $30 or $100 through these small methods, et cetera. And I think that's going to grow, especially as you can now get investment internationally that way. Well, what law applies and how does that work? And it gets, again, more complicated. And I think at some point there's going to have to be a streamlined process, especially for the very small types of investments that are out there.
So, what's your final advice that you give to startups, entrepreneurs, and investors on minimizing the risk of lawsuits and navigating them effectively if they arise?
Don't put a hat on that you don't normally wear. If you're not a bookkeeper, don't do your books. If you're not an attorney, don't draft your contracts. If you are not a researcher, don't go in and start manipulating the data. Things like that. You got to make sure you have the right people to do the right job. And if you are not able to fund that, you need to wait. You need to step back and get the right people involved, because in almost every situation where you are cutting corners on the right people to do the right job, you end up either A, creating a lawsuit that destroys you, B, running afoul of regulations that will end up shutting you down, or C, finding investors who look into this and say, there's no way I'm going to put my money in here. Um, you know, many investors bet on the jockey and not the horse. That is, they know a really good team can bring a mediocre product or service to market and make money, whereas a bad team can create an absolute unicorn of a product and then crater it. And they want to bet on the team who knows what they're doing and has a plan and is methodical and thorough and has some foresight and takes the right risks. And if you don't wear the hat, you don't know what risks that hat needs to take. You know, you stick in the role that you need to stick, and that's absolutely number one. Number two is never ever have a verbal promise. If something's important, document it. Period. End of story. Verbal contracts always end up hurting somebody and creating lawsuits that don't need to exist. And number three is not just hiring the right people, but hiring the right people. That is, people who have integrity. Integrity is a huge deal to me. If the people aren't who they are supposed to be, if they have problems with the truth, if they have problems with seeing reality, if they have problems with ego and control, you're going to end up spending more time managing your team to do basic tasks than you are getting your business off the ground.
That's great. So how best for listeners to get back in touch with you?
My firm, Wisler Pearlstine, has a website, Wisler, W-I-S-L-E-R, Pearlstine, Pearlstine.com. You can always reach me at 610-825-8400. I handle matters all over the country, so I'm always interested in talking to people no matter where they are.
Great. We'll put your contact details in the show notes. I want to thank you for joining us today and hope to have you back for a follow-up soon.
Oh, thank you very much. Very much enjoyed talking to you today.
Investor Connect helps investors interested in startup funding. In this podcast series, experienced investors share their experience and advice. You can learn more at investorconnect.org. Paul T. Martin is the director of Investor Connect, which is a 501c3 nonprofit dedicated to the education of investors for early-stage funding. All opinions expressed by Hall and podcast guests are solely their own opinions and do not reflect the opinion of Investor Connect. This podcast is for informational purposes only and should not be relied upon as a basis for investment decisions.